Good morning, everybody that's online. We'll get started here in a little bit.
All right, good morning. We're going to try and stay on track. I really want to welcome everyone to our new season, our new year for JCIT. We've got a lot on our plate, and so I am thrilled to see so many people here, and I assume ready to work. I want to welcome Justice Clinton. She's from the Fifth Court of Appeals in Dallas. She's joined us. And Judge Peebles is from Houston. He's a district court judge there, and he is online with us. So those are two kind of new members. I see a lot of fine returning faces, and I welcome our guests as well. I'm going to ask you to take a roll call for the people so we all know who's online.
Sure. Online today we have Bob Wessels is joining us online. Mike Caro. Clarissa Webster from OCA is listening in. Judge Stith, Dean Stanzioni, Dina Williamson from the Florida Criminal Appeals, Doug Gowan from Kent County, Ed Wales from Harris County. You mentioned Judge Peoples, he's online. Roland Johnson, Sion Shilhab from CCA, Beverly Walker from Fort Bend. Those are our online friends.
Excellent. Thank you all for joining us, and we will try and remember that you are there and online so that you can be fully involved in all our conversation. So I'm going to start with basically checking, going and seeing if everybody has read the minutes, and if they have read the minutes, if someone would make a motion to approve those minutes, it would be appreciated.
Just the same as I'll move the approval of the May 16th minute meetings.
All right, thank you. And then, give a second?
I have a second.
Okay, so Tracy is seconded, and so all in favor?
Aye.
All right. And I would encourage you to definitely, before you come to the next meeting, be sure and read the minutes and just make sure that we have your attendance. Because we do look at attendance at the end of the year, just to kind of say, okay, who is involved, you know, who maybe isn't involved, and you know, and consider, you know, rolling off or whatever. So, thank you for that approval. We're gonna move into our committee updates. We've got a review of our committees, and if you, you know what, I didn't introduce you. This
It's okay.
this is one of the most important, if not the most important person
Not at all.
that is here in terms of helping us understand the operations of our courts. He is with the Office of Court Administration. And I also see Blake Hawthorne. Thank you very much for coming. He is the clerk of the Texas Supreme Court. But Casey is who will be mostly communicating with all of you throughout the year. He's the one that follows up with committees. And so he is kind of our administrative person that is always very helpful and can answer your questions. So Casey, do you want to talk about the committees and lay that out?
Sure. So generally speaking, this is the full committee, JCIT, and it's split into several subcommittees. Some of the subcommittees that we have from last fiscal year that we're moving into this next fiscal year include things like pro se access. Justice Doss is helping head up that, and that talks about a lot of the guide and file issues that we're having or not having, just monitoring that and making that smooth as possible for pro se litigants to be able to access justice. We also have a standard subcommittee, which is chaired by Bob Wessels. And so that committee is mainly tasked with reviewing and updating the technology standards used by JCIT. We last year expanded the technology standards to cover more than just e-filing. It now covers research and is about to cover our new statewide analytics system as well. So we expect the standards committee is going to have a lot of work in standardizing things that occur out in the courts, or at least when it comes up to the state systems, that it's all the same and we're all speaking the same language. Tracy's heading up our e-filing document access subcommittee. So she'll be talking today about case notices and us turning those on at the end of this month, the beginning of next month. And that's the replacement for case alerts, which
Right.
will give notice of things going on. And then finally, at our last meeting, we identified 2 additional working groups, if you will. And those are in the minutes. So we did write down who the names were. And so if you got tagged, you've been tagged. But there was a subcommittee created to talk about how confidential documents or secure documents have been implemented across the various counties and the inconsistencies therein. We continue to notice that with Research Texas as we implement. There are some clerks who had never had any intent for any of these documents to go on the web. And so when you look in their case management system, everything is wide open. There is no security, because why would there be? We were never going to put these on the web anyway. So there's that group. And then finally, the other group that we created at our last meeting was a bulk data review group. you guys will remember, the people who've been here a long time will remember that when we started e-filing with this current system in 2012, 2013, there was discussion of, okay, all this data is coming into Research Texas. We need to be able to get this data back out. And then at the time, JCIT said, well, we're having enough fun with e-filing and getting stuff e-filed. Let's talk about this later. Well, as time goes on, we're getting pushes from lots of different wanting access to the data that exists inside of Research Texas. And Tyler's let us know that those APIs exist and we can turn them on. But there's all sorts of policy. The technology of it is completely there. The policy surrounding all of that and how it works and who gets what money and how it's paid for, all of that needs to be discussed and recommendations given to the court on how to proceed with that. And so with that, those are the quick summary of our committees and what they're up to.
Right, yeah, no, and so we've got some work to do, definitely based on kind of what you've heard now. And generally over the course of the year, issues come up and we create new committees. And I'm assuming that we'll probably be creating some new committees for work to be performed this year. So what I'd like to do right now is basically, Bob, are you on?
Yep.
If you want to give the standards committee report, that's great.
Good morning, everyone. During the last session of the legislature, they created some new case and filing types, and that's what is reflected in the standard 10.01. And as I recall, that's the only change. Is that correct, Casey?
That's correct. And they introduced two new things, and it was around it's under injury and damage, and it's cyber things. So cyber financial, damaging somebody financially using artificial media and damaging somebody's character by using artificially generated sexually explicit images. So both of those are already a crime, but now not only can you be sentenced, or not only are you liable criminally for it, you're liable civilly to the victim as well. So that's a new thing. And then there's, in addition to that, there's surrounding things in research that say none of these cases can be shown to the public and you can use pseudonyms and all this crazy stuff. So we had to split them out so that we can protect them in research.
Okay. So Bob had, so on our version 10.1, has that gone to did we send that to the Supreme Court? We haven't yet, right?
We have not yet.
So we need to vote on, do you need a vote today on that?
Yeah, given that they were passed by the legislature, I think we need to move that we adopt them and move them on to the Supreme Court.
Okay, all right. Do you, are those, I saw
They
included in the minutes and that were sent around?
No, they weren't, because it's occurred since then.
Yeah,
The law
that's
was
okay.
passed.
That's
Can
right.
it be dropped into chat perhaps?
I'd have to go grab them. I don't.
Yeah, we would need to take a look at them, and that may be something we want to circulate to everyone so that we can either do an email vote after everyone's had a chance to look at them, because I remember seeing them, but at this point I can't even, I mean, I need my computer.
Yeah, it's a very small change. I'll circulate that, Judge, and we can take an electronic vote on it.
Okay, so you'll be getting a copy of the 10.1 update for the technology standards. What happens is we submit this to the Supreme Court and we hope that the Supreme Court then approves it. So we'll circulate that. We're able to have an email vote or an electronic vote. And so you'll be, voting members will be asked to vote, and then we can then submit it. And if you have any questions, we'll delay it until we can discuss it at our next meeting. So we can do that as well. But I think they were pretty straightforward and pretty much ran along the lines of the legislation.
Yeah, I mean, it has been adopted and by the legislature and signed by the governor, so I don't know what choice we really have.
Well, correct. I agree. I agree. Okay, so e-filing document access committee. You are up.
Lord, it has more document.
Tracy, do you have something to show us or,
Yeah, well, it's nothing to show, but I had my,
oh, your notes, okay.
No.
Sorry.
okay, it's not open, so I'll go off and do it, but, oh, there it is. So basically, we've met several times since our last meeting and discussed the e-notices rollout. And worked with Tyler to get the FAQ page updated on Research Texas. And so now the FAQ page actually announces the e-notices.
Okay.
We picked the date of going live of October 1st of 2025, and that announcement is already on the website. And the FAQs for, the differences between e-notices and case alerts. And, how the whole thing works as far as it's integrated counties that will get the e-notices
Mhm.
that are integrated with Research Texas. Only attorneys will get the notice. And it's for civil and family cases. So those are set up and ready to go. And the way the committee worked out was, Casey and OCA was going to have webinars. There's gonna be an eye contact message from Tyler that was sent out to all the attorneys that have e-filed in the past year. Is that what we're going with?
Yeah, I think we can go with that, yep.
Past year, and send those webinar announcements as well as the announcement of the case notices going live, to them shortly after this meeting, I'm hoping. So sometime today, that will go out. Also, there'll be announcements sent to all the clerks in the state of Texas, and I'll put something out on listserv. Actually, something already went out on listserv because they saw the date in Research Texas, so I told them I'm gonna give them more information after this meeting. And then, the webinars will be Thursdays and Fridays at 10 a.m. starting next week until the September 26th, before they go live on October 1st.
Okay. All right. So because we have a couple new members, or would you mind in more simple terms, kind of explaining what your committee did and what the point was?
So basically, we went through all of the case notices and how they would work in Research Texas. Came up with that the county had to be integrated for these case notices to go out. And I want to say there's at least 50 or so counties maybe that are already integrated, basically.
What,
How many are integrated with Research Texas?
today?
Yeah.
222 clerk offices and then another what? 15 Monday?
Okay, so a lot more than I thought.
Yeah,
How many?
we're over 50%. 222 as of right this instant, plus another 15 on Monday. And they're gonna start flying out the door in blocks.
Gotcha. So with those integrations, Tyler put together, because they had just case alerts, and now they put together a program for case notices. So any event that gets integrated and updated in Research Texas for a case, those notices will go out to the attorney of record on those cases. The only time it would not go out would be on sealed case documents. Other than that, they're going out to the attorney of record for those cases, for civil and family cases. Trying to think of what else. So we put together an FAQ page that is up on the site, so attorneys with questions have that. These webinars, we put together and explain the differences between case alerts, which Tyler has that an attorney can sign up for.
Yeah.
And e-notices, which will automatically go to that attorney once an event is integrated with that account
Okay.
or a case.
Okay, and then do you want to just refresh us all and the new people on what does it mean to be integrated with the
Sure.
system?
So, for all members, we all know that we live in a very decentralized environment, so each elected clerk has their own case management system. And so then where that causes pain in our judicial system is that everybody's individual, so individually implemented. So we all know there's 443 different ways to conduct a trial court clerk's office. I know there's 17 different ways to do an appellate court. So when you implement technology in a court, all you've done is implemented in a court. And so what integration does is kind of put a veil of centralization over the top of that so that we're all talking apples to apples. And then that gives the ability for data to flow up to a statewide system and then back down to the local court system in a way that they can understand it and consume it. And so for e-filing, it's the difference between when a clerk hits the accept button and then they have to download a copy, open up case management, create an event and upload it into their system versus hitting the accept button. And it just magically shows up in their system because the two computer systems talk to each other.
Good, excellent. And what is kind of the date? I know we're gonna be moving fast. What is the expectation of total integration?
Total integration, the deadline is November the 1st. We're gonna have a smattering that are gonna pass that. But in Evan's presentation, there's a slide that shows you how we're going,
Okay.
and we're well over 50%. And we can talk to the progress on that.
Okay, that sounds good. Any questions?
Mark has his hand up.
Mark,
Go ahead.
Okay, good.
We also, just real quick,
Oh,
we
good.
also have a way in Research Texas in case they didn't get to the email notice, in case it went to spam or whatever happened. There is a way in Research Texas that we've had them build to see a history of all their notices. So they have an icon that they can click on and see every notice that was sent to them.
And
Excellent.
that same goes for the clerks, or the judges. So if an attorney comes in and says, well, I never got that notice, or really, clickety click, says, here you did, I'm sorry.
Exactly. Okay, Mark.
Go ahead, Mark.
Hi, good morning, everyone. Where did we land on a centralized opt-out procedure, as in the case of family law cases, for example, which there are quite a lot. It seems that it could be possible that any attorney ever on a family law case, no matter whether it's the initial case, a divorce or a SAPSR, or a later case like a modification or enforcement or motion for clarification or any number of things, could start getting notices of all the new filings in the second or third round or of the case. I know we talked about this, and I think we made a recommendation to have an opt-out procedure so that there's some of those attorneys aren't sort of force-fed water through a fire hose, if in fact that's possible.
I don't think that got built in, correct?
No, that's not built in because the last discussion that we had was no opt-out.
Yeah, well, they can't have, you can't have just, I think I'll opt out, and that way, you can't tag me, right? And so the opt-out was not for that. But Mark, I do understand, and we did discuss a problem with family law where you have the case just continues and can continue for, umpteen years through the different lawyers that get involved and that sort of thing. So if new lawyers are involved, are the old lawyers, they're automatically dropped from the case? How does that happen when the lawyers go, okay, so it's 10 years later and they're doing a modification or something? And so they've gotten new lawyers. So those are the lawyers that file the new modification and they're in there. But is it in the system, are the old lawyers still part of that filing?
they're still listed. They're still listed, I think by default in at least our CMS, as lawyer on the case. So the question is multifold, becomes like, a lot of people just start sort of click serve all. And that's a business process, as Casey would say, issue, right? The other thing is that if there are automatic notices that start going out, it's going to be going to old lawyers, possibly old pro ses. If somebody was listed as a pro se, sometimes attorneys are putting in the pro se to give them their own clients notice, I think. And so that's the likely problem. And I thought we discussed this. We had, I think, a number of discussions. Tracy can refresh my recollection about the distinction between civil and criminal, about having to file a motion to withdraw. Is not feasible or even possible, I think, to tell, the tens of thousands of attorneys you have to file a motion to withdraw with your local clerk on every case that you used to be on in order to opt out. That was sort of excluded in our subcommittee discussions, I think. And so I thought the technology for building in an opt-out procedure and then rolling it out. And I thought we discussed this in one of the meetings, general meetings, about having that promoted at the time that we roll out this new function.
Okay, Cynthia, you have
I would just wanted to say, I don't think it's very realistic to expect courts to keep track of who is the lawyer and who isn't, because
Right.
sometimes lawyers join a case instead of are replaced. And so I think it's incumbent upon attorneys to also communicate with the courts. I'm substituting in, I'm adding on. I know I don't practice in family law, it's criminal, and in some of our criminal codes, it says you must advise us if you're representing this person on a writ of habeas corpus. So there's got to be a give and take here. And I think as lawyers, it's incumbent on us to tell a court, hey, I'm still on the case. I don't need to do anything, or I'm substituting out, or I'm done now. I'm withdrawing from the case.
Yeah.
I just think that's expecting too much of clerks' offices and courts to do our job for us.
And I don't think of it that way. I think there was a
Right.
fundamental difference, a fundamental distinction in our prior discussions.
Someone else is
between-
talking, Mark.
Okay.
Go ahead.
You have to take into account too, that there are rules about withdrawing.
Yeah.
And there are ethical obligations that
Yes.
go along with being on the case
Yeah.
as well. And so I think one has to be careful about coming up with some sort of automated solution or
I
something.
don't think there is an automated solution, and I don't think Mark, I mean, I think Mark will agree with me as well. There's not an automated solution in the sense that each case is going to be different. Did the lawyers withdraw? Did they not? Are the lawyers kind of, there's now a new lawyer, but they're taking more the lead lawyer, but these people are still along with it. And so I think that they just need to follow through with their regular sort of, oops, I see that this case is now active again and let's withdraw. And that's what would normally happen.
Yeah.
Mark, is there an issue with that?
Almost all lawyers in almost all family law cases, when the case is done, put the file away and are no longer the lawyer for practical purposes. If we were to mandate this sort of an unfunded mandate, if you will, that all lawyers in all family cases now file a motion to withdraw, we're going to create a very, very, very clogged system for the district and county clerks that handle family law cases.
No, they're not doing anything different than they would do whether it was automated or not, Mark, in the sense that when it's refiled and the clerk by paper is required to send them by paper back in the old days and notice that this is going on, at that point, I know that what I've seen is that the lawyers from the originating case or whatever then withdraw. So it's no different from the practice that's ongoing, right? It's so they need to file their motion to withdraw. You can't just opt out of notice. That doesn't mean you're off the case. You're just not going to get the notice of what's going on in the case. You're still there until technically you withdraw, right?
Patty has a comment online saying
Okay.
that the lead attorney should be replaced by the clerk with the new attorney.
That's if there's a motion
Yeah.
to substitute counsel.
Right, that's right.
Right,
Yeah.
and so from a technological perspective, all that case notices is doing is asking the CMS, who are the lead attorneys on the case? These two, great, email them and tell them this happened on the case.
And yeah, and so it's incumbent then, I think at that point for the lawyer, if they're not going to represent them, to withdraw at that point. Mark, I see your point that a lot of lawyers do just shut the file and close it. But when they get a notice and they don't want to be on the case, they need to withdraw. Yes.
So in criminal cases, this happens on a original case and then a probation violation
Yes.
case. And many times, the attorneys do the same thing. They shut it, they don't do a motion to withdraw, and then a new attorney is appointed on a probation violation. So under Research Texas, both attorneys may be getting the notice. But that means that because of Research Texas, that the lawyers are gonna be forced to do what they should have done, which is after the case is over, do that last slip of paper that says we withdraw at this point. And if they themselves get reappointed, then that's a new appointment, but then we're not relying upon a substitution that never happens because we see these as two different phases. Or in a divorce case or something like that, a post-decree or something like that, that may cause new attorneys to appear. So I think what we're talking about is forcing lawyers to do what they should have done, that in our systems right now, they're not forced to do. But I do agree with whoever said it at the end of the row, that attorneys, Blake, that attorneys are supposed to do this under the rules and there's ethical obligations. And so to disregard that, we're not forcing a new mandate by doing this, we're just getting lawyers to do what they ought to do.
Well, I would just say that frankly, the fact that you get a notice, I mean, opting out of getting any more notices in a case doesn't fulfill your obligation to withdraw is what so I don't think the fact that you get automated notices really affects whether you withdraw or not, Mark. I mean, you tell me what you're thinking.
My thinking is there's a distinction between civil and criminal cases, and that there is not a black letter requirement for an attorney to withdraw, especially given that 30 days after the plenary jurisdiction expires. How could you then consider the same attorney to be on the case?
So Mark, though, the thing is, okay, so they were on the original case. I'm talking about family law, where your case number and everything remain the same and it's going up and now there's child disputes or something else going on in that case. So the clerk is going to send the notice to the party that was on it at the original divorce, perhaps. And if they don't want to be notified anymore because they're not counsel, then the answer is to withdraw. The fact that you don't want any more notices is not going to solve that.
I was just gonna say on the issue of ethical obligations to withdraw, where we used to see this all the time to Supreme Court with some criminal termination cases,
Yes.
prior to the court saying that there was a constitutional or a statutory right to counsel. And we would often see attorneys that wouldn't file in our court because they just assumed they were done.
Yeah.
But the court felt otherwise. And our research into the ethical obligations told us that there was an obligation to withdraw.
Yeah.
So, I mean, we can debate that, but I think that's an important point and something that if we were to decide to do something automated, we should have an answer to that question.
Yeah, I was gonna jump in real quick.
Right.
I think the question we're talking about is not a filing committee
I agree.
question. It's a
It's not.
question about when the representation comes to a termination. If you have a final judgment, is it not a final judgment? What jurisdiction, if any, does the judge have the ability to allow withdrawal after a judgment signed? I think those are more fundamental questions that we got to decide somewhere else.
And I know you had your hand up.
I did. My name is Michelle Legg. I'm with the Attorney General's Office Child Support Division. And we have this issue. I was a line attorney in San Antonio. I am now at state office. I still get notices on cases that I'm not covering. So the Attorney General's Office doesn't withdraw. We're still a party to the case, but the notice needs to go to a different office and not me anymore. So there's that little wrinkle in there too.
So it's a substitution.
Yeah.
It's a substitution.
You know, but for me, at the end of the day, if you look at this, And then there's controversy further down, and then it goes to the Fifth Court of Appeals, or it comes to the Supreme Court. Now they have an obligation to sift through to figure out where the chain of custody or was broken. And it shouldn't have to be that. My responsibility as a clerk is to make sure that the Supreme Court or the Fifth Court of Appeals have a pristine chain of activities. So if you can be, if you're representing an individual and you no longer represent that individual until we get a motion to withdraw that's filed, and it could be that the judge just signed it just because you submitted it, but we will not remove anyone from a case unless there's a motion to withdraw. We will not add a person to a case unless there's a notice of appearance.
Yeah,
Or
no,
substitution. of
right, exactly. It's not incumbent on the court. I mean, you're under a statutory duty to provide notices,
Yes.
right? You can't stop because someone says, oh, I don't think I want one now.
Yeah.
I mean, you're stuck on the line to provide the notice of that attorney on the record. So,
That's,
I think
I have a
that,
question.
you know, I think that's kind of, anyway, I don't think that the solution is to allow just attorneys, because there's no way to tell if there's no motion to withdraw, you have no notice of really, are they in or out? So there's no way for the clerk to know and just accept that, oh, yes, don't give them notices. I mean,
And clerks will never try to read someone's mind, will never interpret what you're trying to do.
yeah.
And Beverly, you had something?
I'm told by family lawyers here that on divorce cases, on the 30th day, they are actually off the case. So in those simple cases, on the 31st day, could we not come up with something technologically to drop them from that case? I have never practiced family law, so I'm asking you family lawyers that.
I mean, we just don't know if everybody wants to be off the case. I mean, I just don't, I mean, there's a motion to withdraw that you need to do if you want to get off a case. If you've gotten notice and the clerk has you on the case, right? Then there's an easy step, super easy step. And that's just to say, hey, we no longer represent and we withdraw. That's not hard.
And I'm with you on it. It was just only in the case of a divorce, because we've had judges ask us this. Like, since by law, they're off the case in 30 days. In the case of a divorce only, could we just technologically drop them off on the 31st day, if in fact that is really family law?
You know what, that is, again, I mean, I think that's a really good question. And I think that should be explored, but it really isn't, I think that's a different group, or maybe the Supreme Court Advisory Committee or something that talks more about that, as opposed to, you know, we now have automated notices. And I would rather, if I was a lawyer, get the notice and do something than not get notices, and maybe I am the lawyer on the case, you know? I mean, go ahead.
Well, two things. First, everything that I say, here's a disclaimer. That is regarding the county clerk's office in Dallas.
Yeah.
Second thing is, also, when a pro se litigant comes to us and say what happened, what are we able to share with them? I don't know, but aren't you the clerk of the court? Yeah, but I can't, this is the extent of the knowledge that I can provide you.
Mhm.
So for me, it's how do I respond to a litigant, and how do I respond to the courts of appeals?
Slight response.
Yeah, go ahead, Mark.
We are not on the case after the case is closed. We do not have a duty in perpetuity to the client. I think we're off topic a bit. The reason that we discussed this previously is to avoid, or what I call Gretzky this, skate where the puck is going to be, to try to avoid a potential problem once we roll out this ease of service notice type of thing. And so the goal was to create an opt-out feature when an attorney is no longer on the case, not to create tens of thousands of new required filings for motion to withdraw when we're no longer on the case. And I do think, again, I'll come back to, I think there's a distinction between civil and criminal on this, although I don't speak from a position of expertise on the criminal side. And some would say not even on the civil side, but I will defer depending on the time of day. So having said that, we're not on the case. I'm getting text messages from people watching this that are family law attorneys. That we're no longer on the case at that point in time. And so I think with deference to the district clerk's comments, the notice or how they respond to pro ses is maybe a little bit outside the scope of where I was commenting. It was only on notice for existing cases that we are no longer involved in, of which.
So Mark, what do you, okay, I don't mean to interrupt, but I just want to ask you your thoughts. What do you do with if the district clerk is looking and going, I haven't seen a motion withdraw or something. I am obligated by statute to provide notice.
Never had that happen.
Anyway, I don't know whether we even have the right to affect that statutory obligation of the district clerk as far as somebody who's off the case or on the case. I don't disagree with you. I mean, the problem is I don't think JCIT can do anything about the lack of procedural clarity perhaps in this area for the district clerks. I mean, maybe some of the district clerks can tell me when you pull up after 10 years of the divorce, 10 years later, and you pull up the case, I'm assuming some district clerks regard the lawyers that were in that divorce as still valid for that case. Is that
No.
is that uniformly across the state?
I don't believe
That's
that.
what you do to decide who's gonna get notice of that, rather than the last one that was named to lead counsel. The other thing is,
Well, when they file the motion or whatever, they usually have certificate of services for new counsel, right?
new
So,
counsel, then, yeah, right.
yeah,
But I'm not so sure about this point that when the trial court judge issues a final order that you're off the case, I mean, the appellate court will soon.
Yeah.
That's who's getting notice.
Right.
yeah,
That's
that's
trial
true.
Order, so what is it that says that you're no longer on the case?
Yeah, no, like I said, like everybody's saying, right now, I mean, I wish I'd done some research. I wish I knew what the status of all of that really is. But Mark, your point is well taken. But regardless of that issue, I'm not so sure that the solution at this point that we can say that that opting out, having any attorney, the ability, right? It would have to be across the board. I can decide I don't want to have the statutorily required notices. Do you see what I'm saying? I don't know why you would add that, but it looks like, you could just punch the button. Yes.
It's at the intermediate courts of appeals, we get a notice of appeal and they normally serve the other side. The other side has not appeared in our court yet. But we'll put every attorney that they've served on the case and we notice all of them. And
Okay,
then they come
Good
back and
point.
they tell us, hey, I'm still on the case, but I don't want notice. As long as there's a lead attorney, then that attorney will get notice.
okay.
But if they haven't appeared yet, then they'll just file a letter with the court and let them know, look, we're not representing them, Kelly. I know that this is a little bit different from how.
But no, it's a good process.
But-
Yeah.
Yeah, and candidly, a lot of the times, you don't know who appellate counsel is until the brief is filed that identifies trial counsel and appellate counsel. There's not a formal.
Well, it's
The,
down.
the way that that's dealt with is there's a specific rule that says you can file a notice of non-representation.
That's right.
And so what that suggests to me, it's a great point, Michael. What that suggests to me is this is a SCAC issue. It's not a JCIT issue. And if the family law bar, I would wholeheartedly encourage this. If the family law bar wants to get with SCAC or get with the rules committee for the state bar, which is another way of attacking this, and advocate for a special rule or sub rule in family law cases that says you don't have to file a motion to withdraw that then has to be set for hearing and heard and all that. And adopt a notice of non-representation type procedure where it's you file one thing. That would seem to me to take care of the issue as long as that were something that the Supreme Court were to approve or a rule on. So that, it's not a simple issue at all. And I can totally see the problem, but it has to all jive with the general notions of what our ethical obligations are and overall procedure. So I think that's a great point about non-representation.
Yeah, I think that would be kind of an issue, but so going back to really the question, which is kind of before us on the notice, like right now, it is just everybody that's in that district clerk's or whoever's file, and it goes out because that's what they feel statutorily obligated to do. And rather have someone try and technology-wise opt out. And maybe they could, depending on what the clerk does, I just think that they need to do just the obligation is set on the attorney to take care of it. If I was an attorney, I'd rather get the notice. The clerk doesn't know whether I'm out or not, if it's not something that came before him, but that's just my thought.
So the reason I brought it up again was because I was trying to think about how we could use the technology that we have available to us, if it is available, to help the clerks and the attorneys, because the previous discussions that we've had in committee here seem to indicate that we would be telling the district clerk or county clerk, we're no longer on the case, and then it would be on the clerk to take us off. That was the previous discussion in this committee. And so that's why I raised the issue, and it's not on a new issue of whether we are still representing, because we're not. It's just on the notice issue.
Yeah, I mean, I think the attorneys will still be allowed to do that. I would just say they get, really, the way they know they're still on the case, or what's happening is they're going to get that first notice. So everybody's going to get the first notice if they're in there. And then it's just incumbent to the attorney. If their district clerk allows you just to call them and say no more, then that's fine. If their district clerk says I need a letter, then that's up to that district clerk. I don't think we can make those rules for the when and where for the clerks. I think what we can do is just everybody gets notice that's in the clerk's file, and then it's fine for then the attorney to handle it. Because they'd be getting the paper notice anyway. All they're doing is the same people that were going to get a paper notice are getting an electronic notice. And so I'm assuming if they got the paper notice, they would do something about it. So it's not really different from that, but I certainly understand, Mark, and I think it's really worthwhile to either go through the SCAC or go through the rules or take it up with the family law organization to really start kind of saying, hey, let's just do this quick notice of no representation and bingo, it's over. I think that's a great idea. You should carry the ball on that, Mark.
Yeah. Oh, I'd love to ask for a new committee to be and to be assigned, but I just can't right now. So.
Okay, all right.
I think it'd be better to SCAC, because then you end up with the miscellaneous order from the Supreme.
Yeah. I think we're doing no more, we're just doing it electronically than what actually is happening, and I say paper, but by email or whatever today, so. Okay, thank you, Mark. I think it was a really good discussion, and I appreciate and I understand the concern that you had for the unique family law kind of progress of cases, so.
The other thing that we've been working on in the subcommittee is going through the Tyler's issue list and prioritizing and removing or updating that list. I think we finalized that at the end of last meeting. And then the other thing was what Casey had brought up was the e-file only option in e-file Texas, and how some attorneys are trying to circumvent the rule and not e-file and serve, but just e-file only. A lot of cases, and we did receive data from Tyler that gave a breakdown of each case type and filing code, and how many were e-file only and e-file and serve. And it looks like from the figures, 45% of the filings being filed today are e-file only, and only 55% are e-file and serve.
So to add some color around that, and we are jumping around to old business A, but we can do that. So but it's okay.
No, let's.
Because we're making progress. So this was an issue that Sion had originally brought up on an issue that they had seen to where an attorney had electronically filed something and had picked e-file only and then turned around and served the person via UPS using UPS ground so that it takes 7 days to get there. Meanwhile, the clock is going. And then the attorney receiving the service is like, what is this? Why didn't you just tell me when you served me when you filed it? And so that prompted this, let's see how often this happens. 2 meetings ago, or our last meeting, Evan came and said, well, it happens about half the time. And so then the question was, well, is that on a particular case type or is that across the board? Evan sent the data broken out by case type. And it's pretty much every case type is roughly 50-50 e-file only, e-file and serve. I did have
Is debt contract, debt collection, debt contract other, misdemeanor, debt contract consumer DPA, and divorce with children.
very interesting. So,
Is it cost more to serve?
nope.
No.
And not only that is when you go into, or at least the Tyler portal, and go in and say, I want to file something, e-file and serve is selected by default. So you actively have to go and click on it to tell it, don't serve these people. And so then the question to the committee came, and I'm not a lawyer nor a judge or any of that stuff. I just work with you guys, but I cannot think of an idea of why would you not want, other than gaming the system, why would you not want to serve the other party?
In fact, it's costing them more, because it
Yeah.
would be the same cost with e-file and serve, and then you pay extra for the UPS 7 days.
But I put you on your heels by wasting 7 days of your time. On it.
50% of the people want to do that. I think it's either a misunderstanding of what the serve means, and are they thinking that somehow it's going to add additional money or something like that somehow? Who's the one, is somebody in their office not aware of what that means? Yes, Cynthia.
There's gonna be distinct circumstances where you would not want to serve someone if you have an ex parte motion for an expert in a criminal case that you don't have to share with it, but you should have to take extra steps not to serve, right?
Yeah,
I think it should be the default. Why wouldn't it be the default to serve, e-file and serve? I'm not sure why
and that's
that's an
what it is.
option.
It is the default.
It is the default.
It's a default, and they are opting
my
out.
goodness.
And what you just listed though are basically civil cases.
Yeah, those are all civil cases.
These are all civil
cases. Misdemeanor type.
But misdemeanors aren't going to take most of the exports. It's gonna be the felony cases that are taking the exports.
Yeah, it's not,
It's,
I think it's a total misunderstanding. I think.
So
So
Just can't-
debt collection for some reason.
I
is
believe in
at
the
1
goodness of lawyers. I don't
They're watching it.
The debt collection is at 1.9 million filings for e-file only. And then the next one, debt collection other goes down to 259,000. So I don't know why that one case
There
type
is.
is so huge.
So one of my questions to Tyler, and I think Evan, you answered it, that we can, are we able to turn that off so that we just say everything's e-file and serve on subsequent filings?
It would likely take an update to the EFM to do that, to basically remove that field or make it grayed out to where on subsequent files.
But it can be done.
Yeah, it's a daily field, so we just.
Right, because you could always, as a lawyer, what you want to do is actually get them served more like in person and do even faster service. You can arrange all that, right? Or you could arrange it. It doesn't, your file and serve doesn't delete
Only
that.
Rule, again.
I know.
Rule says that if you.
Yeah.
file electronically, you have to e-serve it.
Oh, interesting.
Remove
it. Right,
It's not a.
I can tell you from the justice court case, well, head up, touch on this in my.
Yeah, because a lot of
But
them,
the debt collection, not all the debt collection cases are filed by attorneys.
right, no, that's what I'm
Oh.
thinking.
And I can tell you, have a heads up, at least in the justice court, 87% are filed by attorneys, 13% of mine. So it kind of goes to some of the things Jason said. Now, I think the split out may be because some are represented by attorneys, not survive.
Yeah. That's interesting. Yes, go ahead.
Oh, go ahead.
I was just gonna say, I would be in favor of hitting the brake on changing any switches before we require e-filing on, or e-service on all of them, just because there may be other reasons why they're turning the switch off. I think the Supreme Court Advisory Committee or someone like that may be in a better position to try to dig a little deeper and understand what's going on. We're only responsible for the filing and service portions, and whether somebody's being properly served or not in accordance with the rules is sort of beyond our purview.
We do provide good evidence now, though, that.
Yes, in the reports over.
Something is going on.
I'm fine with that.
Well, what
I
is
just saw this the other day, an attorney.
Sion's on.
Automated certificate of service showed that he only sent it to himself. He claims that the body of it and his own certificate of service that he had served in the e-file system. So I mean, there is.
Yeah, and that is, when you file a pleading, you're also, your certificate of service says that you serve the other side.
Actually, I'm showing her, so there's an issue, like you actually got a UPS. Hey, like his automated certificate of service shows I wasn't served. And look, I got a UPS.
Should we add a blank? Like the automated certificate of service, if it's e-file only, should we add the page to say it was only e-file only?
I think,
One was served or something?
I think when it comes through the note, the automated part of it's been accepted says this was e-file only, right? Or it'll say e-file and serve.
Whenever you look at envelope details of the status, yeah, it'll
You'll
say.
see it,
Just on all the details, not on that.
not on the
page.
email. Yeah, okay.
Yeah.
Or says modify the automated certificate to say
Not
you're
you.
obligated by, yeah.
I just think we need to be careful about this one, especially on a debt collection. If we're talking about case initiation, the attorney is required to
Sure.
use the e-file system. But if the other side is a pro se litigant, they may not have that contact information. If we take that away through the e-filing system, they will not be able to use the e-filing system to file the case if they don't have, like, if we put on there that it's e-file and serve, they have to serve someone. So I think what Blake said, where they would serve themselves, that would be the only way they would be able to, go through with the system if we took e-file away. So maybe we need to dig into these cases a little bit.
I agree. I
and
mean,
try to
definitely
figure out-
I don't think we can make a decision today.
Oh, no, not at all.
You know, I mean, I just think we need to kind of really explore this. Yes,
I was
Justin.
gonna say, on criminal cases, Ms. Orr was saying exactly what I was thinking of. There are cases like for experts and other things where the state doesn't get notice. And so as long as there's a way to exclude people on that serve, because the law says that you shouldn't serve those folks.
Yeah.
Evan, you were gonna say something?
I was gonna say a couple of things. There are scenarios we'll see someone will file only, wait for the accepted, and then turn it to a service only with the accepted documents to the other parties. We've seen that before. It's actually pretty common.
Yeah.
In other markets. We'll see, especially in my father's support days, we see that a lot. So it may be worth service only numbers as well.
Yes.
If those are overwhelmingly more than the filing ones, and it indicates there's a lot more services going out that they should have to keep on serving.
And when they do that, is it the assumption that they don't understand that they could have done it in one fell
Yes.
swoop?
And that's.
Yeah, that's my.
And if so,
thought.
can we add some sort of, hey, you don't get charged extra, you get to do both, like something that just says more clearly.
Choose for what?
Yeah, a couple thoughts, because we forget that this, not so evil, the system's been online for going on 13 years now, so there could be a turnover and sort of an atrophy of user knowledge.
Right.
Where people that are very used to the system when they first got on have sort of, either retired or gone to other things. New users coming on may not be as familiar. Could be, a mass blast to the user base saying, hey, by the way, you can do this out here, it's free of charge, here's what it does. Because, and on that note, I thought maybe a little bit more data around this, so maybe look at the history, like how long has this been going on? Has it started to kind of approach 50-50, or has it always been 50-50? I think it'd be important to look at what are the events that where this is most common, And also, is it pro se versus attorney? What is that, what do the numbers look like there? And also by EFSP. So is it certain EFSPs, maybe they don't default it, or maybe it's a little more hidden on their interface and uneasily to understand. So to the point, there could be sort of an education around it.
And then if you can find the numbers also on, to match up on the only e-file, and then you turn around and serve, like if there's a way to, tabulate those together in a way,
It'd be difficult to correlate those because if I e-file something, I get one unique identifier, and then when I turn around and serve it only, I get a completely.
So you can get straight numbers, but not a matchup.
Yeah, I mean, you could say, what are the average numbers of each on a case and see if they're within their balance. So on a certain case, I have 10 e-filing onlys, but I also have 10 service only, so maybe that's in balance.
Right.
So you could do some kind of back of the napkin correlation there, but there's not a great way those are linked in the system because I don't receive unique IDs.
And Mark has his hand up.
Mark?
Yes, I have a comment from another attorney who's watching online, and so I'll just read this. She says there are examples of when you would not want someone electronically served automatically. For example, if an application for a protective order is filed and an ex parte protective order is issued, I think this was touched on, that it must be served personally on the defendant. And then we've had instances where they find out because of direct electronic service and they start harassing the victim and then dodge personal service. There's a danger issue there.
Yeah, no, I think there are some legit reasons why you don't serve at the same time you file. I absolutely agree with that. And so I don't doubt that, but it disturbs me that we have such a high percentage of people that are not using the service feature. And I take into account basically the JP courts. Those are problematic. This requires,
Yeah,
I think.
Take it back to the subcommittee.
Yeah, will you take it back, Tracy, to the subcommittee now with this, really insightful comments made from different areas of practice? It might be good to kind of figure out more about what's going on, why that percentage is so high. Wow. Okay. All right, so now you've got a new task, continuing task, Tracy. We'll never let you go. Committee will be always operational. So thank you very much for taking that on. Okay. Moving on, Research Texas. Can we hear from you about Research Texas and everything else, Tyler? Are you all gonna give a report?
Yes, Evan is.
Okay,
My turn?
your
It is
turn.
your turn. Just give it a second, yeah. Okay, go ahead.
All right, so those of you who may be new to me or JCIT or online, my name is Evan Acosta. I'm the Director of Professional Services over the eFile Texas program. And historically, I've been involved in Texas since I actually started at Tyler. So I sort of eat, sleep, and breathe Texas. So
Yeah.
you want to go ahead and. So, screen, you're the. I'm not that good. I don't have everything memorized. So, this is our transaction volume count for the last couple months. It includes, again, I'm going in a little bit more detail of some of the newer posts. It includes the user registration counts, and then the kind of very spiky graph is actually the filing volume per EFSP. The state portal receives about anywhere between 70 to 80%. It kind of varies month to month. And that's going to be, again, the HTML5 portal for the Tyler run EFSP. We have about 50,000 filings a day. Again, that kind of varies, but it's very slowly kind of grinding higher and higher. Now that more JP offices are starting to come online. Right now, and actually, I was just checking last night, that number on the JP update is actually false. We actually have all 22 of the top 22 counties have at least one JP office live. And then we have 6 active pending JP engagements. So. And this is our return for correction rates, sort of comparing Texas to the national average, since Texas is actually one of our older, more mature markets. You actually have on average lower than the national average, and that average has been refreshed. I believe it was last year I refreshed the numbers for the national average. So as typical, we start to see the numbers kind of climb up in the summer months. Summer months tend to be a little bit busier filing volumes, as you can imagine. The numbers for the rejection rates kind of correlate well with it. And then this is one of the slides we added back in. This is also the return for correction rates by return reason. I think the ones we've always been really focused on outside of the typical, like, hey, you just filled out the document wrong, you put in the wrong information, so we correct formatting, incorrect information, was the very generic judge's requests and filer's requests. As you see, the judge's request year over year is starting to creep up a little bit higher than the previous year. However, the filer's request is starting to go down a little bit. So some improvement there. And then over to the right are the historical averages of the two selections. And then this is our return for correction rates, kind of a comparison between the county district courts and the JP courts. The tables include the top 10 case types based on the number of return filings. No surprise, the highest volume of cases are going to have the most return filings.
If I can jump in here, we were talking just a minute ago about debt collection cases being the majority of the ones that we're receiving, where documents are not being sent electronically. I was going to look at this data, but I suspect one of the reasons in doing so is they're putting their tongue on the side of their mouth and hoping they can get approved for filing before they actually send something out to not tip off the other side that they filed the debt collection suit.
These are, if you've seen this slide for a few occurrences now, it's the usual suspects. Debt collection, motor vehicle accident, divorce of children on one side, then on the justice court side, same thing, debt collections, and then evictions are actually starting to climb the list. I imagine there's a lot of those moratoriums were lifted after COVID. Any questions?
Just want to comment, in the justice court, the occupational driver's license ends up being a lie. As you saw, the percentage is pretty high for occupational driver's license. That percent. Those take a lot of time.
Yes.
Wow.
Usually the filer didn't provide all the right information the first time, so they had to revise.
Yeah. And this is our self-help, this is our guiding file. So again, sort of a historical slide we've had here for a while. In the bottom left corner, that's the interview completion rate. It's slowly kind of ticked up over time. And then in the top right is the number of sessions completed year to date per county. No surprise, it's the largest, most populous counties that are doing the most volume. Tarrant is usually the number one because they have a really good sort of education program around guide and file. And they really sort of push for its usage. And then in the bottom right corner is just a comparison of the number of sessions that were completed, where they actually integrated an e-file, or the assumption maybe they completed them, they likely printed and brought them up to the board.
So to add some additional color around here, Evan has given me the list of the 46 interviews and what their status is of whether or not they're integrated. And if they're not integrated, why they're not integrated. And we're working with, I know two of them said, well, Harris County this, so I pitched them over to Tracy for her to look at to see what's going on there. And is that old news that we can resolve, or is that something that we need to resolve on the guide and file in? And so we'll likely be working with our friends at Legal Services as well to make sure that things are in a position that we can link them into e-file to go in.
And then I have two questions. Sure. Tarrant County, who is it that we would contact about why their usage is so high in their educational program? Is it Tom?
No, it's Ralph Swearingen in the JP office.
Okay. And then when people don't finish it, do they get reminders, hey, it's still pending, or is it just, you know, they just. The life moves on and they forget about it, or they don't know how to access it again, or.
No, I don't think they'll get any kind of like notifications,
That might be-
but they will see that they have a draft saved of their progress. So they don't really get kind of that they have something outstanding.
Okay.
When you say 46 interviews, what do you mean by that?
So basically the ability to file a case, so an answer to a petition or a divorce case. So it's basically a entire,
Those are all the questions.
all the documents. and questions.
Interview is a kind of
Thinking like turbo.
strange, it's like divorce, it's like contract, it's like there are 46 of those different, different things
One of
that,
them actually is an occupational therapist.
yeah. So
And at the end, the goal is to spit out whatever documents the
Correct.
court needs. And then the hope is to link it up with e-filing. So you could say, well, you've created all your documents. Don't you want to just hit the button here and pay your fees and get the case started?
In TurboTax, they call it a wizard. Like it's the wizard that helps you go through.
Yeah, I don't.
So it's the interview that helps you go through.
Yeah.
Same exact concept.
Of the pleadings forms that have been approved by the Supreme Court of Texas, do all of those now have a tie into an interview?
I believe
Yes.
so, yes.
Yes. And out of the 8 that are integrated, a majority from integrated across the board. So that's something we try to keep up with. As new GP offices go live, we try to connect the interview to there. So it's to all the tokenization that happens in the form, we basically link them up to the codes in the EFM. So whenever the form comes through, it's picking the appropriate case type, the party types, and the fees, filing codes, things like that.
And so on that list, Judge, some of the other things that we'll be working with is some of the individual counties and clerks, because the other thing that I saw on the list was their thing, and like protective order was one of them. That, okay, I have a protective order, how do I file it at this clerk's office? And when you look at what the things are that you can e-file, protective order is not on the list of things that you can e-file, and it's because they have that code turned off, and so.
Correct.
It'll be some one-on-one work at the OCA level to say, hey, you know, you should go ahead and turn this on and we can help you get it linked into your case management system so that it comes in.
And on some of this, what happened, is that, for instance, one of the most popular, I think, ones of these is the divorce one, right? So people will start the divorce, they complete it, they go to file it, and those are returned for correction. Because they don't have all the stuff that that particular court requires. And the good thing is, I talked with Justice Busby and he got access to justice involved. And I think they issue an amendment.
That they added it to the standards, so
Yeah,
that
to the
no local
standards.
rules can interfere.
With the, if you're using the appropriate, orders that the Supreme Court has prepared, they have said that this is okay.
May have started to take full effect, you'll see it on the.
Is it? Oh,
Yeah.
good. That is good. So anyway, that was
It
a
is.
very quick fix that helped fix that sort of. We really have to look for like consistency across to everybody. And then when they start breaking out and creating extra rules and things like that, it often hinders the e-filing efforts that we make. So we try and fix that ahead of time.
So on the next slide, it's very similar to the previous slide about return correction rates. This one is just purely around the guide and file submissions. So the large graph left center, that's the accepted and returned the number of accepted and returned filings, and of course, the line graph represents the rate. So you actually do see a steady drop in the return for correction rate overall. And in the top right, it's actually down over the last time we pulled this about a little over 2%. So
okay,
early days, but maybe starting to see a little bit of a drop. And then of course, the most popular return reasons and the most popular returns based on the case type. So yes, divorce for children is one of the larger ones, then evictions is the overwhelming top dog, all the filings is. One of the things I thought that would maybe enhance this a little bit better, since we're looking at based on case type, we're starting to focus a little bit more on the forms and the interviews themselves. we could actually get it broken down a little bit more to out of those 8 integrated forms, what do their return rates look like? Because the case type could be a bit of a misnomer. Because based on the county, that may be integrated to a slightly different case type depending on the county, but you can actually look at just the interview itself. And then we can dig in the weeds on which counties or offices are rejecting those things.
So can you tell me what judges, I mean, I know what judges request means, but like that seems very broad and nebulous.
So what we, and in the comments below, what I typically do is when I pull this, I'll kind of scan through the rejection comments, and it's usually the same stuff. You're missing some sort of wet signature. There needs to be some kind of seal. You need some kind of notarization. You don't have this particular order form for our county or our judge that we like attached to it. So it's usually along those lines. It's missing some kind.
In previous discussions, it's come up that there are some trial court clerks that will interpret local rules. Like if a judge has a local rule that you must do all this stuff, if you don't meet the local rule, they'll say, well, we're going to return it for correction at the judge's request because you're not meeting the judge's local rule. And not necessarily like a judge saying, you need to send this back to this person.
That is not the majority. It's
Right.
mostly the clerks sending back because there are local rules in place that vary from what the guide.
And they're calling it judge's request.
Right.
I see, because I was gonna say, I don't know of a single judge that's ever done that, but that may just be that I haven't talked to anyone.
One of the things we've looked at as well in looking at that is, some counties, they will attach a proposed order to a motion. Sometimes they will file separately a proposed motion to an order. Sometimes the motion will sit on the judge's queue and the judge will sign something else and then reject it for whatever reason. And so we've got some inconsistencies there as well on why things are being kicked back and why it's getting that code.
Right. But in that case, Justice, those would also go in judge's request. Because the judge said, I'm not gonna sign this proposed order. I've already signed this other thing. So get this out of my queue. All right.
And then
A quick question on that if I can.
Go ahead, Mark.
Yeah, I think in the past meetings, we've really covered that topic quite extensively about judges' requests. And I think that there was some additional drill downs that were going to be done and reported back. Does anybody remember that, or Evan, do you remember that?
Yeah, and I think it was based on around what, if we could see the comments around it, and I do have those listed in the footnotes of both slides, both on the guide and follow page and on the page where we do the return by reasons. And they're generally the same each time. It's you're missing some particular form.
Because at least in Bear, there were a very large number that were clerk driven as was brought up. And the judge, at least 2 judges in a meeting have said, we do not request these things be rejected.
One of the things
I think
the judge was really because the filing information was totally incomplete. On the occupational driver's license, it's virtually always the data is incomplete to meet the filing requirements. So it looks like it's a judge's request, but what are the judges?
But it's actually incorrect info.
Yeah, that's right.
Yeah.
So again, it could be chalked up to educational as well, or just like to say the word, but laziness, just I'm gonna choose the most easy generic one and versus actually pick the right category that it's in.
Or it could be, the judge told me that there's not the right information on this, so I'm gonna say.
So Mark, I thought I heard that you were about to make another comment. Is there?
Yeah, I don't know. I think my recollection is that we were maybe going to try and aggregate some data on the judge's notes so that we would have some data to correlate as to the wrong reasons and possibly be able to address that. But I don't know if it was that specific, or I just my memory is not full on the last 12 months, if you will. So
Yeah, no, I think Evan did do that, but the problem is they're just equally as broad. The judge's request encompasses just broad little discrete things. And as you said, you've got it listed on the.
Yeah, there, some of
Yeah.
the big ones that I saw that were common. You saw the same kind of, a lot of the counties, it looks like they just kind of copy and paste a lot of the same verbiage into their rejection comments when it's judge's request. And a lot of it is you're missing some kind of form.
Yeah, I think it's usually they're missing forms that they are required to use. And lawyers know about it, so they don't get theirs punched back, but it's probably the pro se's that are getting. Because they have not included whatever the court's requirement is, probably in family law cases, Mark, that's what I would suspect.
I think it's different from that, but I can reach out to Evan another time. Fill down.
Okay.
Wait,
Question, how many of these that are the judge's requests don't have any remarks?
Yeah.
Cause, I'm just wondering, you know, like Mark was asking about the trends in the remarks. Are there a significant number of judges' requests that just don't have any? Cause you don't have to put them in.
Yeah, I had to double check.
Okay.
Bob, you had raised your hand for a second.
Yeah, one of the things that we might do is split out from judge's request does not meet local rule requirement or something like that. Get a handle on how much of this really is being driven by local rules.
So we did build the ability in the EFF. That was one of the 2.0 requirements to actually have like I think it's like almost a sub reason that you have to select. So if you select this, it's linked to some sort of local.
Because we've been dealing with local rule issue and additional requirements, particularly in family law.
Yeah.
And if that's
It's not-
becoming a major reason for rejection lumped under judges, maybe we should split that out.
Is there a way to split that out easily, Evan?
Per judge's request? Yeah, I mean, it's just a data field table.
Yeah.
You can just add judge's request dash or whatever, or leave it judge's request and there's a sub selection. They have to choose one
Yeah.
of these things, and then you can actually kind of drill down a little further into the data.
What do we do with that information? And once we figure out that really local rules are driving a lot of return for correction.
Then I want to go back to the Supreme Court and say, okay, the local rules should not vary from, this stuff. They changed just drove me crazy, where everybody gets to have their own local rule. And I told Justice Boyd at the time that could create havoc going forward as they all create local rules that affect the filing deal. So I mean, I think at that point, we can go back perhaps to the Supreme Court and say, hey, can we get a handle on all these local rules that are kind of glamming up the system, is my thought. That was.
Yeah, I mean, we're not seeing like a rise in the overall return to collection rate though. So, I mean, you would have to be able to say, okay, here was the point where everyone had to submit their local rules for approval.
Mhm.
And then after that point, we see a rise in the return for correction rate. Right? I mean, just make the causation case, so that's what caused this. But we're not seeing that, we're seeing fairly consistent return correction rate. So I just, because it's a lot of work to go and look at the data, and I'm just wondering, okay, so we get the data and then what? Then
Well, I mean, in addition to maybe it doesn't change this, but you know what? It's a hardship on attorneys as well as pro se's. To here's a guidance file that says you ought to be able to file and you can't, and you're gonna get it returned. And there's not, the pro se's going like, what? Okay, and so that is really what I'm on for them,
Totally
for
on the
this,
same page.
yeah, yeah.
I've changed myself.
yeah.
But I don't know that you can prove it right now, right? Because, I mean, wouldn't you need to be able to show that there was a rise in return for correction?
No, because they don't even, no, I wouldn't think so, because they may not ever file again. They got returned for correction, they're not sure what they're gonna do. I mean, I don't know. I think that if you want this guidance file to work for pro se's, which is really what it was created for, you really gotta, to me, support it by
Yes,
making it as easy as possible.
They were responsive to that and said, okay.
Yeah,
in a terminal.
Yeah, exactly, exactly. And so,
So
yeah.
that problem.
Yeah, so I would like to see that, you know, I don't know that all courts know that, all clerks know that, maybe it's an educational thing. I just want to see less of that return because they have orders that really aren't allowed anymore glommed on to the requirements for filing.
One justification would be to provide an explanation to the filer on what they can do to correct a problem if they're refiling. Obviously, it gives us the additional benefit of being able to drill down and look at the data, but if I'm a pro se filer and I get something that gets returned for corrected and it just says judge's request and I don't know what that
And
means.
that's what I mean,
Right.
Right.
So
I think
why?
most of them do that.
Yeah, they usually put something in the
No, they usually
comments.
put it in there.
Otherwise, they're gonna just keep refiling it wrong.
Yeah.
I think they tell them what's
Yeah,
wrong.
yeah.
But if that's what they're doing, why do we have a category that says judge's request? Cause they have to then explain what that request, I mean, if it's, you know, if it's missing a form, it ought to be missing a form. If it's incorrect information, it ought to be incorrect information. But judge's request to me seems like it begs for problems.
It does.
Cause it's really not the
Because
judge's
it's totally
request.
vague.
Right.
There's no way to correct because you have no idea.
Well, I would say from the clerk's perspective, it is, if the judges have a local rule that says like in Travis County, you're required to have this, document that has to be attached when you file your divorce decree, that is not a clerk, that is a judge's.
But we can call that a local rule issue.
Yeah, I don't
I
care
mean,
about
what I mean is, we should add categories that actually capture what the problem is and not use the term judge's request, right? Because that's too nebulous. I mean, I don't think that helps a pro se person. Even if you're an attorney and you're from Dallas and you're trying to do something in Austin, that doesn't help those attorneys. I mean, I think that needs to be broken down to the categories that we're seeing coming up under judge's request and get rid of the title judge's request.
I agree. I mean, you know, an occupational driver's license there in front of us. And we're looking at the information, the state requirements. They're not even hitting and answering all the state requirements. So the judges say, no, it's not a local rule issue, it's a state law.
But then
issue.
that in judge's request is that that's the
That's
failure,
incorrect
that's
and
incorrect and complete, isn't it?
Yeah, but I'm not sure,
How they're doing it.
I'm not sure how the courts are actually filling out that.
And I would say it's not consistent from court to court for sure. And even maybe within the same court, it's not consistent from clerk to clerk who's reviewing it. So.
Okay.
So it sounds like there's a little bit of an education issue. If we
Yeah,
want to get rid of the category judge's request as a return for correction reason, I would say we should kick it over to the standards committee since
I
they govern
think-
that and then let that be further discussion there.
Yeah, I think there needs to be further discussion. I think one of the things, Bob, for the standards committee is to remember on the guide and file, we're dealing with pro ses, right? And so really the whole point of guide and file was to make them have the ability to act as pro ses and file something. So what education or whatever needs to be done so that either they know what they need to do to get it filed or the clerks know that they can't just put it under judge's request when there's a court. I mean, we now know that the Supreme Court has said you can't glom on additional orders and things to the guide and file documents. So are there particular people you want for this, Bob, or do you think just your standards committee can take a look at it?
I think the standards committee can take a look at this. I mean, this has been an issue and this topic has probably had more discussion than any other single one we've dealt with over the years. And I think it's time to address it. And I agree with the individual that said we need to get rid of the judge's request category altogether. And I personally agree with that, see what the committee says, but.
Because that helps us know, okay, who do we need to educate? What topics should we educate on and stuff? If we get a better idea of why they're being returned for correction, we can educate the people about it. But yeah, okay, Bob, then this one is gonna go over into your court. If you need help, you know who else could help you is probably the Access to Justice. That committee would, I'm sure, be very interested if you need help from them in any way.
Will you put me on there as an observer or ad hoc or whatever you call it?
Sure.
Because that obviously is relevant to the pro se. and
Absolutely.
file, so
Yeah.
we need to kind of be able to track why.
Absolutely. Right.
You know what, Casey? Maybe we
Yes.
should do a joint meeting
Yeah.
with
we could do that.
standards and access to justice. Instead of going back and forth, let's just have a joint meeting.
That's great.
On
That's
this
a good
topic.
idea.
I'm volunteering
What?
Justice Clinton for that committee.
Yes, definitely.
Welcome, which one?
Gonna recruit her, so I think.
That's a good idea.
Minds think alike.
Yeah, I think that's, I mean, I think this, we can do a lot of good here. Yeah.
Will do.
Two more slides. So this is, just the update on the integration rollout. So left to right in the bottom, the entire statewide, integration status. So we're in about 50%. 17% more of the integrations are actually, in progress, meaning there's either us or one of the other vendors are working directly with the county getting it going. And there are 30%, 46, offices that are ready to heat up. And then in the middle box is actually by CMS vendor. So we, either will be wrapped up probably before the month is out. There may be some, counties that may be a little bit more delayed because at the bottom note, at the bottom or under risk says, there are some clerk's offices that are undergoing some CMS transition. So it's kind of, where can we sort of find the happy medium between them transitioning over and then using Tyler's system to integrate? Or is the current vendor gonna have to work on the integration, and then they're gonna have to maintain that until they cut over? So, one note that, we actually just got a very positive email from IDOC this morning. They're actually bringing, I believe it's 8 different, counties live on Monday. Then we got another 15 teed up, ready to go. So as Casey mentioned, a lot of these, especially from like IDOC and Net Data and LGS, they're gonna come in big waves. So I expect to see that number shrink very drastically.
So,
Ask the question.
yeah,
Is all guide and file being operated by Tyler? Do we have other CMS ties in with clerk's offices that have their own interview process, or are those independent?
those,
They're required.
Yeah. Sorry, go ahead.
I was gonna say, guide and file acts as an EFSP.
Right.
So it's on the front of e-filing.
Okay.
I believe there's one other EFSP that operates like is Turbo Court still around? Are they doing any traffic? I haven't looked at those. Yeah, there may be 1 or 2 other EFSP providers that offer that same service.
So without regard to which service the clerk has decided to use, we could integrate some sort of guide and file for their
Oh,
office or kiosk or
Totally.
whatever, if somebody wanted to come in.
absolutely.
Great.
And also adding color around, this particular slide, one of the things that we've elected to do is separate the case management system on the back end so that, you've got EDOC, Net Data, iDocket, LGS, and Tyler. Since the clerks are their customers, rather than having Tyler go to the particular clerk and saying it's time to integrate, we know, oh, you're an LGS customer, so we're gonna work with LGS, and LGS is gonna help you clerk because they're your customer. And so we work with the different CMS vendors. On the Tyler side, when it's time to turn on that integration, it's a quick note to Evan and his team, and they flip a switch in coordination with the CMS vendor. So what that's resulted in is what we see with LGS and iDocket, and NetData and eDoc are actually very close to getting their integrations done, in which case we'll start seeing the same thing. But, Evan will get an email from LGS and there'll be a block of 10 or 15 counties on that list. And then all of a sudden they'll be the integration is in progress. And then a week or 2 later, we'll get okay, we want you to turn these counties on this date, and we'll coordinate on our end.
Oh, nice.
And then, so we then just get blocks and blocks of counties coming online.
And then off to the far right, just kind of an aggregated look at just for flight total progress. So we're past the halfway mark in terms of completed and progress.
So it sounds like we're confident that EDOC and that data are working and getting things in gear and we'll.
Yeah. So yeah,
Okay.
that data this week actually got one of their final APIs. They got successful tests on it. So now I think they're just kind of bundling everything up, maybe do one more big smoke test and then. Ideally, it'd be very similar to what I doc nailed yesterday. Just give us a big lump of counties. We'll get them staged. You guys verify things are working and then we turn them on.
Some other things under the risk category, one of the things that we did see with some of the net data counties have not integrated with e-filing today. And so that means that still today, those court clerks are hitting accept and then downloading a copy of the document and then opening up their case management, entering an event and uploading the doc like a very manual process. And so Net Data is working with those customers to try and get them integrated with e-filing as well as research. And so we're starting to see extension requests come in from them and those counties because they are asking for more time beyond November 1st to get all of
Are
that.
those mostly the smaller counties?
Yes, everything in flight 3 is under 60,000 in population.
Okay, okay.
Yeah, EDOC's in a similar boat. They've got, I think they're only SFTP integrated.
Oh, so they may be the same way. Yeah.
They're working on, I think Wilson County and a couple others are actually working on EFF integration.
And then the only other risk on this one is and we've seen this and OCA's been able to go in and help the trial court clerks where this happens. Every once in a while, we'll encounter a small county where, like I said, they've never put anything on the internet, had never had any intention to put anything on the internet. And so in their records, they don't have the notion of sensitive or confidential. And so the concern is, well, if I turn this on, all of a sudden, all this sensitive confidential stuff is going to be out there. And so when that happens, our court service division goes out and helps that clerk establish security in their local case management so that they can start moving along with that.
Yeah, and of course, it's on the call. She's been a godsend.
Yeah, I know.
This phase, she can kind of help translate into clerk speak what they need to hear to help get moving because we explain it and I think it doesn't quite resonate as well as when she does. So she's been fast.
Yeah.
I'm sorry, and can I ask you of that, 146 of that 33%, what's the population size?
Under 60.
You've got
Under 60,000?
Yeah, you've got everybody it's probably the top 50 size counties are all integrated. We're getting into like Delta County and whatnot. There's a couple big ones out there still like the planet. But they're
both county and district clerk.
They're going from EDOC to us, and I think so. We'll see where that lands, but I know actually I just got an email that we're starting up their e-filing and research integrations side on our side now, so.
All right. Let's see if I can, so, there we go, okay.
All right, and then just one final announcement, we're actually getting rid of our H5 platform, which is our, not the very first e-filing platform, which is Silverlight, which that's been gone since 2020. We're gonna have the old H5 site, so it is gone as of Monday, and when we say gone, what we mean is if anybody tries to hit the H5 site, we're just gonna redirect them to the new EFSP site. It'll still be online in the background. We'll probably keep it on another couple of weeks or so, just to make sure nothing blows up. If something does happen, we can easily just remove the redirects, then you filers can go back to the H5 site to kind of help. But we're pretty confident in this switchover. We've done a whole lot of performance overhauling to move EFSP. We even selfishly for Texas put it in other larger markets.
I was gonna say.
Like we didn't want to just throw it in Texas and watch it crater, so we put it out in other markets that do have a very high volume. We monitor the metrics before and after, the performance is excellent afterwards, so very confident in this, very excited. Some stats along the bottom, it was up for almost 12 years. Yours truly actually is the first person to implement it, put it together. About 47.3 million filings went through that portal, all said and done. And that portal registered a little over 225,000 users. I think it's 225,333. So it's a really easy number to remember. And then the nice thing about the EFSP, it's not, we call it new. I put it in quotations. It's been around for 4 years now, actually 5 of the markets. It currently receives anywhere from 45 to 50% of the filing volume on any given day. ECF5 compliant, which ECF5 is that's going to be all of the new functionality we're building, such as the bulk filing. So bulk filing will be available in the EFSP. In fact, I think we're turning that on a little bit later this month or next month.
Next month.
So
we figured we should only make one change a month to the attorneys.
So, yeah. On that note, we are fully expecting that nobody saw bright red text at the top, the 1,000 or so email support flyers. So our support teams will be ready for the calls on Monday, wondering why my bookmark isn't opening my site.
And originally, when we started announcing this, we saw the volume at like 70-30, 70 of this one and 30 of the other one, and through communication and just word of mouth and pushing out, we've now got it at 50-50. And it's like, there's nothing else we can do other than just cut it and let everybody go to the new one and make sure all of our training and support's ready to go.
And there was there's like an overwhelming hatred for this site, but it still received the overwhelming volume of the I think a lot of people truly miss the original Silverlight version, so.
Yeah, I don't. Tracy, do you miss the Silverlight version? Nope.
I continue to get envelopes packaged up incorrectly and fees done incorrectly.
Is this one where it flips your?
Right,
Yeah.
until this goes away and I'm like, turn it off, and it's like, oh, we can't get it, so I'm like.
Monday.
I can't wait for it to return.
Yep.
So I know a lot of people did it.
Yes.
Yeah. That's why we have it emblazoned at the top. This portal will be closed down starting Monday, 9/15.
No one's gonna.
That's okay. If I can't, all I can do is put it in a red at the top of the site.
And we've got pop-ups in the site too, when they log in, it sends them another little.
All right.
That's it for me.
That's it.
Okay, thank you.
Thank you.
Thank you very much. Okay, we're gonna skip and go to a report for the justice courts. Thank you very much, Russ, for getting this together for us, and I think it's gonna be pretty informative. We're trying to push e-filing forward to as many of these justice courts as we can because they are handling volumes of cases. So Russ, why don't you take it away?
Okay, thank you for the opportunity. First time we did this report, the chairman's request was in 2019. At that time, 11 of the 16 largest counties in terms of population were e-filing and represented about 46.7% of the state population. And so I'm looking at population and technology kind of hand in hand. There were 12 other counties filing, and all but one had a population of greater than 80,000, and that represented 5.3% of the state's population. And there were a total of 78 JP courts. Okay, just to let you know, there are 803 JP courts across the state, and so 78 was a small number. So where are we now? And all 16 of the largest courts are accepting e-filing, represents 67% of the state's population. And it's being done through 114 of the courts. There are 44 other counties also e-filing, representing another 16% of the state's population. And the population ranges are fascinating. We have one county with 5,261 population and they're e-filing. That's awesome. But the range of those was up to about 76,000 and they represent another 1%. So here's the remarkable progress. We went from 23 to now 60 counties as of last week participating in e-filings, and that represented 86% of the state population. And the largest number of e-filings in justice court on the civil side are debt collection followed by evictions, and much smaller called justice court filings. It used to be called small claims, but we no longer have small claims court. And many administrative hearings, and you heard me talk a little bit, and others talk about things like occupational driver's license. We do a ton of these other administrative filings. Attorneys appear to be representing 87% of the debt collection type filings. Okay, so they're not doing them all, but they're gonna. So I tried to simplify everything down to about 6 slides. Issues identified. 100% participation by all the JP boards with 26 of the 51 largest counties. There are another 12 counties where they're doing partial filings. What that means is some courts are accepting e-filings and other ones are not, even within a county. And what we're finding out there is within those counties, those courts that were accepting e-filings, their caseload went up, and the ones not accepting e-filings, their total caseloads went down. So it's incumbent really to get everybody, all courts within a county up and running. A discussion or survey of those courts not accepting any file in those same counties where courts are accepting may find that there are some solutions forthcoming. I think we need to have some discussions just with those counties. Some 9 counties of the 51 largest are not accepting the filings at all. I think good. We need to figure out what needs to be done to get those other 9 courts involved. I also talked about mandating certain types of filings might be considered. And the only area where I see a high percentage of the debt cases being filed by attorneys are debt collection. I think you've seen some other data that suggests that collection is a big deal. If we were considering any mandate, and I'm not sure whether we should or not. I said that it's unclear whether mandating would frustrate or complicate other types of filings, such as evictions. Justice courts are the courts of original jurisdiction for all evictions, so, but a lot of those are not. Okay, exceptions. There are 526 justice courts, mostly in small counties, representing about 13.3% or 4.2 million people of the state's population that do not, cannot, or likely not to have the financial or technical resources to support e-filing. Summary. Well, you can see them. 51 largest counties represents 86% of the population. And the state population grew by 3.5 million since 2000. 26 of the largest counties appear to be fully integrated with all courts participating. Another 12 of the 51 are partially participating. I think we need to find out what's going on with those. Some of the largest counties that aren't participating, I think we need to find out why they are and try to encourage those. If all the courts, once the 51 largest, it's just 277 courts, that would make up that 86% of the state population. And again, 13.3% are unlikely to ever do that. If we were to consider mandating for any type of cases, it would appear that the only one would be debt collections where their high percentage are by law firms. The ones that aren't law firms, interesting, are some large stores that actually use their own personnel to file instead of and of course you just still have some individual ones. Further comments beyond this update, the Justice Court, will perhaps abolish jurisdiction of issues from dangerous dogs, occupational driver's licenses, which is the big one. We're the court of original jurisdiction for homeowner associations, among many other administrative hearings. We probably do as many administrative hearings as we do debt collection cases. Demands for jury trials skyrocketed during COVID, which created increased case management backlog. And part of that was due to emergency declaratory orders coming from the Texas Supreme Court. There were 60 of those. We had to keep track of them every step of the way through. And so at the end of 2020, it looked like we'd incurred a huge backlog. Well, most of those issues have been resolved passage of time. E-filing has been a real benefit in large counties. I want to thank Casey and Evan for all the work. This was a big data dump, and so I said thank you to those two for giving me a lot of data. Some of it I think recently.
Thank you very much for that. You have a question on the mandating in civil cases outside of justice court. We require attorneys to e-file, so we have a mandate for attorneys, but not for self-representative litigants. And I wondered what your opinion is about how that would affect justice courts if we had that type of mandate.
Over time, we've had some attorneys who still file. They're mainly one person firms are actually not filing electronically. So I don't know how much of a disruption that is. I think it will put a lot of pressure on those small law firms that don't know that e-file to mandate that they e-file. But those are typically not on debt collection cases, but on some it is.
So as you know, coming from the justice court perspective in at least one of the, higher populated counties, I think it would be great to have it mandated, just like it is for district and county courts with attorneys only. The only caveat that I have, or addition, I guess I should say, is with us, our biggest e-filings are evictions. Our evictions take up over 50% of our e-filings in Collin County alone. And we have all of our JPs doing it. So we actually have something in our local rules about if you are an apartment complex with 50 units or more, we require you to e-file your eviction cases.
Is that a local?
What county are you in?
Collin? Yes.
Is that a local?
And the Collin County JPs put it in there just to say, to do that, but they did, whenever I told them I was coming here today for this, they did ask, hey, can you see if that's an option? Just because even if it had to be broken down by, the population of the county, but those apartment complexes, they'll show up with stacks, and they want all their receipts right then. I mean, it's when they could have just sat and e-filed it, because most of those are filed by a property manager.
Okay, that's.
Yeah, sorry, I was getting there, sorry.
That's
Yes.
So David, go ahead.
Since we're on the issue of possibly mandating e-filings, I'm David Wilms. I run a process service company in Houston. We e-file all of our returns of service. I would like to suggest to the committee that commercial entities and law enforcement, process servers, sheriffs, constables also be required to e-file their returns of service. I don't know how we were left out a dozen years ago, but I've gone into Constable Rosen's office in Houston. Here they've got stacks of returns from the constables that they got to enter in one by one. And it doesn't make sense to exempt those who are getting paid a fee to provide this service, not to e-file. So I just want to toss that out in terms of discussion of mandating e-files, because there's a lot of returns that are sent in paper.
So it sounds like it's a dissection of what do you mean by pro se, meaning that like, if you're.
It's generally done, I'm talking about commercial.
Oh, no, I know, but I'm saying like from that standpoint, if pro se is I'm not an attorney,
Well, we're
then.
not pro se, we are non-party filers.
Right. And so I'm wondering, like, is there a way that we can dissect that so that we can say, like, what Jessica's saying, what David's saying is, these are commercial entities, they're doing this, they're not, these are not people that are like, you know, access to justice, need help filling out a form and working the service. This is part of the bigger machine.
So on the return versus the service, are we talking about, you know, basically the actual institution, you know, the instigation of a suit? In other words, you're talking about the process servers, they go and they get someone to sign off, they've signed it, they've done a little affidavit on the service of citation, right? And so your thought is that then they would e-file that?
They should be required to.
E-file that, okay, and so,
Whether it's a commercial process server or a law enforcement.
and so then I'm just trying to understand the process. So then they end up with it, holding on to the original, they have the original and just throw it away?
We get a file mark copy back electronically.
Okay. Yeah, that's what I thought. Okay.
Yeah.
Okay.
Yeah, the whole idea of originals is kind of gone by the wayside.
Oh, I know. I'm just trying to figure out the process, so.
I'm saying people who get paid to do this for a living, us and sheriffs and constables should be required to do that.
Much like the same with people in apartment
complexes. Yeah, but you could probably make that distinction based on the, whether it's a company.
Yeah.
I mean, I think you could, just kind of brings to mind the, unauthorized practice of law and, you know, the idea that corporate entities, partnerships and things like that have to have an attorney.
Yeah.
So we kind of make that distinction, but individuals, of course, can still represent themselves. And so it seems to me that this distinction, essentially, like if you're a company, then you need to e-file. As opposed to you're an individual filing on behalf of yourself.
Good point.
And we can work out the details. Yeah, I'm just bringing up a high concept.
Yeah, you know what? I think that's I definitely think that's worth looking at. In terms of the.
Full disclosure, I have an interest in this because we include e-filing in our price. If we mandate others in my same industry to e-file, they may raise their price to cover that cost.
Yeah.
So I don't want anyone to think that I'm doing this just for the benefit of the system, although I am.
Yeah.
But I need to disclose that my recommendation also has a business interest.
What's the current process they are using? They're not e-filing it. Are they picking it up and walking it over to the clerk's office, and standing in line and stamping?
Yeah.
Yeah, what if the distinction we would make and it mandate would be essentially that electronic filing is mandatory except for individuals representing themselves? Yes.
Yeah, that's what it's
That would
saying.
be, that would be good, because for county clerks, all JP appeals come to us. And my office is paperless, and we have to scan paper, and that's just, that makes no sense whatsoever.
The only result you're going to get is law. That's the pushback.
So we're looking at both JP as well as commercial process servers.
It would be any court that presently has an e-filing mandate. Any non-party filer would also need to e-file their returns of service.
Okay, what I think we need to do then is create a subcommittee unless what we would put this under. What do you think?
I think that it would be a new group.
I think it's a new group, definitely. Does someone want to get involved? I know Russ, you're in, good, thank you, sorry.
Wouldn't that be part of the rules? Because that would be changing the rules.
Would it be changing? I guess it would be changing the rules.
You're changing the e-filing rules.
Changing the e-filing rules, so that are probably the standards, right?
Well, it'd be
Yeah.
the old rules.
Okay, so we look at process servers and JP.
Well, I like Blake's term, anybody that's not representing themselves,
Yeah,
Yeah, that's the easiest way.
right.
any individual is not representing themselves.
And I guess the other issue, whether they're charged a fee for it or not, is not really a determination.
No.
We do not have to pay to e-file. So we're incurring no fee. We have software set up, but it's not an incremental cost to us.
Yeah.
I'd be full of claims.
Casey, add me to that. This Bob.
Huh? Hey, Bob, what about it?
Okay, and Tracy's remembering our rules committee from when we did e-filing
Yes,
12
exactly.
years
Yeah,
ago,
exactly.
and that committee no longer exists,
Okay,
so.
so we're gonna make a new committee. All right, so Russ is gonna be on there for JP as well as Jessica.
Yeah,
Okay.
the president of the Justice of the Peace Association is Carlos from Travis County.
Oh, okay,
So I think we
excellent.
can
So
just
you
make
guys,
sure-
okay, that's all good.
We need to include them because they'll do what because they'll do the buy-in if they decide.
I won't lead it, but I'll be a part of it.
Okay, Tracy,
Okay, on a side note, the property code was silent, has been silent on what to do with squatters or, and this last legislature has now passed a law to deal with that situation and not involving the courts. So if a landlord, wants to evict, they can go directly to law enforcement and the courts aren't involved.
nice.
That's why it's been a roll.
What is the note? I thought that they changed the notice period, they shortened the notice period, but you had to get to that, I knew that. I wouldn't. Where here?
That sounds like effective, change makes all passage.
All right, okay, so process servers. I think we gotta, okay, does anybody want to represent the process servers, whether you are on the committee or not? Okay. Okay, Tracy, what's this? Okay, anybody else want to be on this kind of examination of the process servers and the evictions and trying to get some JPs?
I'm not volunteering, but someone should reach out to law enforcement because it sounds like from our
Oh, yeah.
conversation, that's gonna be one of the biggest
I
hurdles.
think,
You'll get some pushback.
Velva,
Yeah.
you identified Carlos.
For the constable, but there's also a sheriff's
Oh,
association.
okay.
Okay.
Yeah.
Okay, so we need someone from law enforcement or someone definitely in the know with law enforcement. Anybody got some recommendations or thoughts?
Maybe somebody from TCO, since they license the law enforcement agencies.
I'd reach out to somebody over at TAC.
Okay. All right, Bob, if you'll reach out to someone in CAC, that would be great.
David Escamilla, that thoughts on law enforcement.
I didn't hear you.
David Escamilla. No.
Oh, yeah, David might know someone. Reach out to him.
I can tell you what David was talking about. We are in the process of doing that electronically in our county.
Oh, you are?
It's a process that we're trying through our back-end integrations with our case management system, document management system,
Okay,
and the constable's tracking system. So
interesting, okay.
so we are in the process of doing that. We're trying to get everything else done electronically. We started with the protective orders first. And we've been successfully electronically delivering those to the constables. And then we're trying to move on to other service documents. It's just slow going because of all the legislation that's came down, just sidetracked.
OCA
A lot
keeps
of
changing
adjustments
stuff.
and all these OCA changes that keep coming down the pipe. Kind of delayed a little bit, but we are in the process of trying to get it done.
Okay,
But that might be something, as the community's looking at it, it might be a county to county thing that they want to back end integrate. And not go through the state portal, kind of like what we did with criminal, where we had some exceptions that we could file and say, hey, we want to do this through our back end system. But we're gonna do it electronically, but through the back end system, not through the state portal. So it might be stuff to look at.
And currently in Colin, we have the same thing, so we actually use Civil Serve through Tyler since we have enterprise justice for our case management. And we were able to send all the citations from district, county, all the courts over to the to their system electronically, and all the returns come back to each court electronically. And so we don't even have to print everything, we just hit docket, it automatically attaches to our case and we're done. It updates everything.
Yes.
Wow, that's,
Travis County does the same. We have our own internal system that we created where most of the constables are doing it, but it's not a Tyler product. It's called agency upload, and we've been doing it for years, so I would prefer to be a more broader electronic system than just e-filing.
okay, anybody else want to be on this committee? All right, so, which needs to be chair? Anybody want to volunteer to be chair? Where is the whole committee? Anyone?
Are they on
Anyone?
JCIT?
Because I'm about to designate.
Bob Velpa, yes.
Oh, no.
Judge Ridgway? Bob?
Anybody online? I see nothing. Oh, gosh, okay. Okay.
How about Jessica?
Uh-oh. Bob nominates Jessica.
So Jessica, I think you and Russ should be co-chairs, because this is your, this kind of came up through you. And so, so if you don't mind kind of getting together, just to kind of talk about how to proceed with your group.
I'll work it.
Okay, yeah, and he'll send you, I've got scribbled notes and they will all be made wonderful once we.
Yes, we will make them look pretty.
And so we, and so we'll know exactly who's on this committee and everything else, but I think that would be a very worthy kind of accomplishment for us to finally get to the point where we can do the e-filing of processes and things like that. All right.
So, Judge, we are now 3 minutes over, so we can go fast though on the last, there's
Yeah.
one more piece of new business to talk about, and then there's another piece hiding behind that.
Okay,
Um,
let's do it. Usually we end really promptly on time.
yes,
but
and
we
we'll
had
go
some-
very quickly.
Yeah, we had some lengthy
Um,
discussions.
on-
Document access fees, is that? what we're
So,
on?
yeah, document access fees, OCA had received a letter from Harris County asking about consistency in document fees. And this has to do, I believe this probably was, the impetus of this is when Tracy and them integrated with research. And so on the county portal, the county charges attorneys on the case for copies of their documents.
No, not.
No, not attorneys on the case
You don't charge.
We charge if you're like a pro se or you're.
or your pro se.
Or
Okay.
if you're just wanting a copy of this case, even though you were somewhere later, somewhere down the line.
So on research does not charge pro se's for a copy of
Right.
documents on their case. And so,
It's basically party statistics, right? So if
Right.
you were named party, if
Yes,
you're not an
it's-
attorney, attorneys get their courtesy copies. But if you're any other party, you're able to just get whatever copies you want, whereas we charge per the statute the 10 cents a page or the dollar.
the dollar amount. So the question is do we want to change research to start charging parties and do it like the counties do it, or keep it the way it is today? So I would say, I don't know what subcommittee you want to look at that, but we can pitch that off to that group. Whatever you want to look at that.
But Tracy, you're charging the pro se because of the statute now because it's a discount fee.
Correct.
Yeah, that.
Horses.
I mean, if attorney wants a certified copy, they still have to pay. the fee.
Yeah.
Yes.
That's still the same. Let's see, you've got the pro se access. There's an access to criminal, but that's on the criminal side. Standards or Tracy's e-filing document access subcommittee.
Isn't that document access?
Yeah, it is. So we could give it to that committee.
Okay, we can give it to you, Tracy, but is there anybody else that wants to get involved? I mean, in this.
Is there, yeah. is there
Yeah, I mean, we'd like to.
I don't know what the,
Anybody else want to be added to that subgroup
what the law with,
for the pricing?
yeah, the price.
Tracy, would you like to know?
I don't mind serving. This is Patty Henry.
Okay, Patty, thank you. Way to go, stepping up. I appreciate it.
Well, Patty's already on.
Oh, she's already on the committee. Well, you can be on the special focus group.
She's not, maybe it was Laura.
Okay,
That's right.
yeah, okay, that sounds good. All right, anybody else? Okay, you mentioned a sub little.
The hidden
consideration.
one, and I think we're good with this, is an easy kick over to the standard subcommittee. As we start bringing criminal documents on research, we're getting, requests from counties to add other things onto the criminal in addition to what we've already approved, so, if you're game, I'd like to push those requests over to the standards committee
Yeah.
to start looking about expanding what we're doing in the.
Are there other case types? Are there types of cases that they're trying to expand
It's,
to?
I think what's happening is that, I think it's Tyler's fault. I'm gonna throw them under the bus. They're getting,
So
they're getting rid of their
Yeah.
portal, and so there are data elements and things that are in that portal that do not exist in research. And so,
Yeah, it's basically a scenario where you can't properly identify who the party is, because we don't have any personal identifiers at all, no date of birth, no address, no anything. So it's virtually impossible to know if you have some sort of common name that we're looking at the right person in there,
so,
as well as the documents outside of the 5 that have been approved.
right, so today the standards committee has approved 5 different document types to go on criminal.
Yeah,
And they've also approved the data elements that show up on the page or
Yeah.
that you can search by, so. The request that we're getting from counties is what else can we
what else
add
can
to
you add to
that?
that? Yeah.
But Bob, I hope you don't mind me saying that I think that should be pitched over to the standards committee to look at.
Yeah, I do too. I think that's
Why
a
not?
good place. Hey, Mark, did you have a question?
No, I just put a note in the chat. If someone could add me to this, if there's a subgroup and it's not just in our regular document access committee on the pricing charging issue.
Okay. Okay, this is going over to standards then, and Bob, you have my permission to contact any additional people that may not be present to also include them in any of their committees that you have been kind of assigned to, okay? All right, anybody else have anything they want to bring up as far as the e-filing or anything else? The other areas you want to look at for now? All right, so I think we have a lot of work to do between now and our next meeting. Can you remind me of the next meeting date?
I believe it is January the 9th. Did I get that right? Somebody wanna?
Yes.
Okay, good.
All right, next meeting is January 9th. The subcommittees need to meet. And what we do here is really develop, kind of just run with the ball, and then we look it over again. So we're gonna have a big meeting in January because we'll have a lot of things to look at. So I'm gonna encourage you to get to work. And the chairs, your job is to wrestle everybody into, having meetings and that sort of thing. So, with that, no further business, we stand adjourned.
Oh,